U.S. Representative Louie Gohmert sued Vice President Mike Pence in the Eastern District of Texas federal court, asking the court to prevent Mike Pence from following the text of the Electoral Count Act, which is an 1887 act, on January 6th to determine the president by counting the electors. Subsequently, Vice President Pence filed his paperwork asking the court to go ahead and dismiss the lawsuit, stating that Louie Gohmert was suing the wrong party in suing Vice President Pence. They suggested that Louie Gohmert should go ahead and sue the House and the Senate, since they were the parties whose power would be challenged in the lawsuit, and that if Louie Gohmert were to sue Mike Pence, their goals would be aligned, as it would be an increase of the vice president's power. I don't think that argument necessarily follows, but that's the argument that they went ahead and put forward. Well, just earlier this evening, the court did go ahead and dismiss this lawsuit, but not really for the reasons Mike Pence requested. Instead, this court followed several other courts throughout the nation in stating that Louie Gohmert lacked standing to bring the claims. Let's talk really quickly about what standing is and why the court says Louie Gohmert lacks standing in this case. As always, I will have a link to this document in the description of the video if you want to read the full order. We're not going to do that. I'm going to summarize what's in the order to go ahead and help out here, okay? So, the court said that Louie Gohmert lacks standing. Standing is an idea in federal court, and it is to give the court jurisdiction over the subject of the lawsuit. It's called subject matter jurisdiction. Very complicated. But the idea is that there has to be a case for the court to hear, a case or a controversy. And I talked about this a little bit in the earlier video about this lawsuit, about what a case or controversy is. And in this case, it was specifically in regards to the declaratory relief being sought by Louie Gohmert. Louie was asking the court to declare this act unconstitutional. He was also asking the court to restrain Vice President Mike Pence from following the text of the act. Okay, so that's where that falls down. But what happened is the court decided that because there was not a case or controversy from Louie Gohmert to even challenge this, not necessarily with respect to Mike Pence, that it should be dismissed for lack of standing. Now, there were other plaintiffs involved who were registered electors, and the court did say that their claims were not traceable to Mike Pence, even if they might be otherwise injured. But let's talk again about standing really quickly so we can understand this legal concept. Standing is the idea that there must be an identifiable injury to the plaintiff. So in this case, we'll talk Louie Gohmert as the plaintiff. There must be an identifiable injury to him that is particular to Louie Gohmert. It can't be general. It can't affect a general population of people who are similarly situated. And this is the issue we're going to run into. But it must affect Louie Gohmert directly. Okay? So next, that injury has to be fairly traceable to the defendant. In this case, Mike Pence. So that was the argument that Mike Pence had, was that the alleged injury that Louie Gohmert would sustain would not be fairly traceable to Mike Pence. And then third, the court has to be able to grant redress or to fix the problem between the plaintiff and the defendant. Once you get past that first two steps, the court has to be able to go ahead and step in and fix it. Okay? So in this case, it failed at the first step. And the reason it failed is because there is a very specific Supreme Court case which says that you cannot have standing simply for being a member of Congress. But this plays into the general idea of standing, because all members of Congress are similarly situated as members of Congress. Okay, and we saw this in Lynn Wood's case in Georgia as well, where he was suing as a voter. And they said, well, just because you're a voter, everybody who's over 18 or whatever, generally speaking, is a voter. That's a big group of people, and you're no differently or particularly situated than them just by being a voter. So in the same way, they're saying this about Louie Gohmert. Even though it's a smaller subset of Americans as congressional representatives, they're saying that you are this subset, and all of the members of this subset are similarly situated. You're members of Congress. Louie Gohmert's argument was that he would be prevented from actually casting his vote constitutionally if Mike Pence read a slate of electors, if those electors were contested and they had to go to a 12th Amendment debate in the House and the Senate, that Louie would be prevented from voting. The Electoral Count Act dictates that the members of the House will vote individually, not as state delegations. And there are legal scholars and legal talkers out there who think that that is improper. They think that the 12th Amendment implicates the state delegation voting that we would see in the case of a contested election. That's not really settled other than by the Electoral Count Act. But the court is saying here that Louie Gohmert's situation is the same as every other congressman in the House of Representatives. So he's not particularly injured in any way. He's not singled out and he's not targeted. Therefore, he lacks standing to bring this suit. And this has been a consistent thorn in the side of all of these elections. But it leaves normal people out there who are not judges and who are not attorneys saying, wait though, if it's unconstitutional, I don't give a damn who has standing. I just want the court to answer the question, is this constitutional? But yet again, we will have a court avoiding answering those questions on the standing doctrine. And there are talkers out there who are also very successful attorneys like Robert Barnes, who has done election law cases, who will suggest that things like standing are ways that the court can exercise politics and have the excuse of a named doctrine to hide behind. That standing isn't a real doctrine, so to speak. I mean, it's real in its effect. It's real that it can definitely shut down a case, but that there isn't consistency even within the same courts. And in many ways, I agree with Robert Barnes on this, especially in the context of these election lawsuits. It is a politically expedient way for a court to avoid answering very, very difficult questions. So, the question for Louie Gohmert is, what's next? I assume they will be appealing this and trying to get an emergency expedited hearing either at the appeals court or maybe try to take it directly to the Supreme Court due to the amount of time that is left before this count is going to happen in 5 days. But that is what's going on. That is why this is dismissed. I should mention again that there are other plaintiffs in this case, and theirs was similarly dismissed for standing, but on the second prong that Mike Pence is not the appropriate target. Now, the most frustrating part of this is that the court says that this is all speculative, and that that's another aspect of it. Basically making what's called a ripeness argument, that the injury that may occur to Louie Gohmert hasn't manifested yet. Of course, by the time the injury manifests, the court would say it is too late to provide a resolution. So again, issuing the problem or addressing and entering the same problem we've seen over and over and over throughout these election lawsuits. You cannot sue until the thing happens, but once the thing happens, the courts have said it's too late to sue. So that is a problem, and the courts this year have been signaling time and time again that they are unwilling to step in to deal with these election issues. A sharp contrast from the year 2000 for Bush v. Gore, when the Supreme Court did step in, and not only did they stepped in almost unexpectedly to take a specific issue with the election. Every court in this, every federal court, I should say, in this election has decided to stay out of it completely. And they have used doctrines like standing, latches, and mootness to avoid answering those questions. So I hope you learned something from this. Let me know what you think below. Are all the courts in dereliction of duty, or are the courts the true patriots here? What do you think about it? Let's engage in discussion down in the comments below. Also, if you're not subscribed, hit subscribe. Lots more like this coming up. News with a little bit of legal explanations thrown in, and there's plenty more to come. See you soon. Peace. Peace.